Morning, Your Honors. My name is Steve Kragoza. I'm the Special Assistant Public Defender for Mr. Brewery. I'd like to reserve 5 minutes. All right. This is an appeal about a conspiracy charge where the state set the parameters of the conspiracy as being and, or the conspirators being and rather than potentially and or. And in this case, for example, the state attorney's office said that Mr. Brewery conspired with Victor Hernandez and Mickey Jean-Pierre and unknown persons. Now, I suggest to the court that when the state attorney's office is using the parameters of and compared to and or, they're stuck with what they're charging him with. For example, when you look at the evidence for unknown persons, the state attorney's office presented no evidence whatsoever of any unknown persons. So I suggest
your argument on the impact of that is, I think, based on our decision in Tersigny versus State, which deals with the and or thing and says and or is fundamental error, which I think is based on our prior decision in Cabrera versus State. That has been, those decisions have been disapproved, or at least Cabrera's fundamental error decision was disapproved by the Florida Supreme Court in Garzon v. State. I guess my question is, to what extent does the Florida Supreme Court's disapproval of that reasoning affect your argument?
I'm not arguing fundamental error, Judge.
Okay, well, your brief does.
No, my brief didn't argue fundamental. The Attorney General's brief argued fundamental error. I never claimed this is fundamental error.
Whereas Mr. Brewery moves that the motion of judgment of acquittal be granted, or that this court find it was fundamental error for Mr. Brewery to be convicted on the conspiracy charge.
Convicted of conspiracy under these charges. I'm not saying the information was fundamental error. My argument is the information is whatever it is. And the information is saying that the conspiracy was with Mr. Brewery and 3 other people or groups of people.
Right. So you've not cited any law on what the effect of the use of and is. Basically, what I have seen in the case is that where a statute, when a statute contemplates acts in the disjunctive, and information that charges in the conjunctive is not a problem if any of the one things that it charges in the conjunctive is proved at trial. And I'm just kind of wondering what your reaction to that is and how that applies here.
Well, you know, that's initially how I had been looking at it, because a lot of case law about jury instructions and or. But the difference here is this is how the state charged it. So it doesn't really matter the conjunctive, not conjunctive. This is a charging decision the state attorney's office made to say, we're going to charge conspiracy with and, meaning, I mean, this is their decision, meaning he conspired with 3 other, or with Mr. Hernandez, with Mr. Pierre, and with other unknown persons.
Right, and what I'm saying is your brief doesn't cite to me any authority that tells me what the effect of that is.
Well, right.
And there are cases out there that says where the statute under which the state is charging an offense contemplates acts in the disjunctive, and the information charges in the conjunctive, proof of any one of the things separated by the conjunctive is sufficient to conform to the charging document.
All right, let's assume that's true then, okay? But what I'm saying, though, Judge, is that's not what the state did. All right, if they're going to say and, that's what they did. That's what the charge is. Even so, when the court looks at the other potential conspirators, was there actually a conspiracy? So even if the court considers and says, well, the and is no big deal, even though the state set these parameters of this, so what? The question still comes down to the conspiracy. A conspiracy requires intent and an agreement. Let's take it backwards from what the state charged on who these conspirators are, based on that standard and or, for example. The state said, well, unknown persons. There was no evidence presented of any unknown persons. So that one's gone.
But that happens all the time.
I'm sorry, Judge?
You're arguing, I mean, I haven't heard the words yet, but aren't you making some sort of...
I'm sorry, I couldn't hear
I
you.
haven't heard the phrase yet, but aren't you saying essentially that the information was constructively amended during trial? Is that kind of where you're going here? Because I don't find this argument strong, and you may want to spend some time talking about why there was not a conspiracy of two or more people.
Right, that's what I'm doing.
In this particular case.
Right.
Is the evidence that Mr. Brewery ordered peeling off of prescription labels that someone else did, yes or no?
Mr. Mitchie, no, I don't think that's sufficient evidence to show conspiracy, Judge.
I'm asking whether or not that's true on this record, that he ordered Mitchie to peel off the labels from the
that's correct.
prescription bottle
That's correct.
containing a controlled substance.
That's correct, Judge.
Okay. Continue with your argument.
All right.
Did they drive down to Fort Myers together?
Yes, they did, Judge.
Sounds good. Thank you.
All right. But the issue still comes down to, okay, well, let's look at Mr. Mitchie, what his role in this was. He's the one who took a phone call from the confidential informant. And what the state attorney's office said at the motion for judgment acquittal was the reason they were using Mitchie is because he conveyed information to the appellant. Well, the problem with that argument, conveying information, is that Mr. Mitchie was dealing with the informant and got the information. So obviously Mr. Mitchie could not be conspiring with the informant. And at this point in time, there's no evidence he was even conspiring with the appellant because he's dealing with the informant. The informant calls and says, tell Mr. Brewery that I want to get these pills, or I want this information, all right? That is not a conspiracy in doing that, and we're conveying information because...
The evidence would have permitted a jury to infer that Mr. Mitchie, in fact, relayed to your client that there was a request to buy 400 oxycodone pills.
And I don't dispute that.
Okay. And he gets in the car. The evidence would have allowed the jury to infer that he got in the car with your client
I don't
to drive
dispute
to Fort
that.
Myers
I agree.
to meet the confidential informant.
Right.
And the evidence would permit the jury to infer that at your client's direction or request, he got the bag and moved through it to start removing labels off the pill bottles, right?
I don't dispute that.
So why is that not sufficient to take this out of the realm of mere tangential connection and take it into the realm of agreeing to traffic 400 oxycodone pills?
The reason is this. The first segment, which is court to saying conveying the information, would require that for that information to be given to Mr. Brewery, there was already an agreement between the appellant and Mr. Mitchie that any information he gets about any drug trafficking, anybody else, would be transferred to him. That's not it. We don't have that. So the fact that he relayed the information, or Mr. Mitchie relayed the information to Mr. Brewery, doesn't show anything other than he relayed information. And not only that, Judge, the appellant didn't return a phone call based on that. It was the confidential informant, again, had to follow up on that. So even though the information may have been relayed, that does not show a conspiracy because conspiracy requires intent and an agreement. Where was the agreement that Mr. Mitchie had with Mr. Brewery that he was going to provide information? That's not there. So I suggest that cannot be used and say, well, that's part of the conspiracy because there's no...
Why couldn't one infer from that a willingness to participate in the underlying transaction?
Well, that's something different.
You could have just as easily not gotten involved, right?
I agree. Well, I'm not saying there's not maybe potentially show a willingness to do it. But the problem here still, Judge, is for a conspiracy, you need intent and an agreement. All the evidence shows... Okay, so let's assume that there is an indication of a willingness. Where is then the intent and the agreement that Mr. Mitchie wanted to conspire with the appellant to get these pills? Just because he's in the car with them? He missed, that's all. And
pulling labels off of
but he was told,
he
didn't, I understand, but he didn't do that. He was told to do that. And not only that, Judge, The labels he pulled off when they looked at it don't amount to trafficking. All they still show is a potential conspiracy to sell. The state attorney's office said that the reason they needed Mr. Hernandez in this was to get to the trafficking amount. And Mr. Hernandez only had...
Mr. Howard.
I'm sorry, right, Mr. Howard. And Mr. Howard only had one pill bottle. The label was not touched. So the best case scenario under the court's reasoning is that potentially it was conspiracy to sell, not conspiracy to traffic. And when you look at what the state attorney's office is saying, like for example, let's go to Mr. Howard. What exactly did he do? He had a pill bottle, lawful pill bottle of the pills. He was not in the car. The confidential informant says, I don't know who this guy was. I don't know what role he had.
Could a jury have made the inference that pill bottle, that his possession of that pill bottle was not lawful in light of, one, the communication from your client to the CI the day before the accident that I'm working on getting more pills, and two, the fact that the date on that pill bottle was the date before the transaction with the confidential informant, and three, that he was in the car with the confidential informant, or with your client that went to Lee County to meet the confidential informant? Okay,
well, as court's asking me, could the jury have inferred that?
Yeah, could the jury make that inference?
Well, I think the jury can make any inference, but I think the question still comes down to, Judge, an inference is not proof beyond a reasonable doubt that Mr. Howard was involved in a conspiracy. Where's the agreement? Where's the intent? And the other issue here is the state attorney's office itself is not saying that Mr. Howard was, how he was involved in this. Their whole argument, the motion for judgment of acquittal, was we need his pills to get to the trafficking amount.
Oh, they need his pills to get to the amount that was agreed to be delivered.
No, that's not what they said. They said...
But isn't that as a factual matter correct?
I don't remember that, Judge. I don't know if it was it. Because, I don't think it came down to how many pills were in Mr. Howard's bottle. I think it basically came to there was a certain amount of grams. It was under the traffic amount. When you take that traffic amount and you add the other one, it came to it. I know there was the transaction was for 400 pills. And I don't believe, though, maybe I'm wrong here, I don't remember, though, that the amount of pill bottles, the amount of pills in that Mr. Howard's bottle were actually identified.
But the amount of pills in the other bottle were less than 400.
I can't say that, Judge. I'm sorry. But even so, it still comes down to what was Mr. Howard's role in this. And was there an agreement? We were dealing with a conspiracy. Now, okay, there are these implications, and it does look suspicious. You got a guy in a car. He has the pill bottles. I mean, I do criminal law. I do trials. And, but there's a difference between proving something beyond a reasonable doubt and not. And when it really comes down to Mr. Howard, okay, it may look kind of suspicious what his role is. He just happened to be in the car. He just happened to have his pill bottle. It just happened to be a certain amount of pills. The problem still is, what is the state proving here? You could imply anything. The question is, was conspiracy proven beyond a reasonable doubt? And when the state's whole argument as to the trafficking, the conspiracy, is we need Mr. Howard to get to the trafficking.
Well, actually, the question is whether a reasonable jury could conclude that he was guilty beyond a reasonable doubt.
Well, isn't it also the evidence that the state has to prove beyond a reasonable doubt?
Right, but we're reviewing a JOA, right? So the question
no, and I'm also arguing there was no evidence. What I was saying was fundamental error, Judge, was that a person cannot be convicted of a crime that did not occur. I'm saying that's what the fundamental error here is. So if it's not, so when you're dealing with a fundamental error as to this crime, did this crime actually occur, the conspiracy to traffic, when only evidence they have of a conspiracy was nothing other than nothing? When we're dealing with the state's evidence and the state's summing up his evidence, we need Mr. Howard to get to the trafficking amount of pills.
Mr. Vergosa, you're at the 15-minute mark.
All right, thank you.
May it please the court, Jeffrey Siegel on behalf of the state. We ask that you affirm the conviction for conspiracy to traffic oxycodone 28 grams.
Counsel, you
or more.
need to pull the microphone a little closer, please.
Is that better?
Bring it up higher.
Higher? Is that better?
Go ahead and
Can you hear me
talk.
now?
Let's see what we've got.
So the state had approved, yeah, that sounds a lot better, 2 elements, which was an intent to commit the trafficking of oxycodone 28 grams or more, and there's an intent to carry out that agreement. And we have the facts of this case is that the CI calls up the appellant, but ends up getting a hold of Mr. Pierre, Mitchie's Pierre, and then eventually CI calls up appellant again and actually gets a hold of the appellant, and the appellant says, hey, my buddy, which a reasonable jury can infer that's Mr. Pierre, says, hey, you need four of these, which could be inferred that's 400 pills. So anyway, the deal gets set up between the CI, then appellant, and Mr. Pierre and Mr. Howard go to Fort Myers from Miami, and the CI comes all the way down from, I guess, Tampa area, and they meet, and Mitchie's in the car, Howard's in the car, and the appellant says to Mr. Pierre, tear off these pill labels. And that's how we get conspiracy, Your Honors. We have enough to prove the prima facie case here, and then a reasonable jury can infer that, hey, this conspiracy happened with Mitchie Pierre, Howard, and people unknown or persons known as well. As far as the Howard argument, there was about 400 pills. There was about 200 pills in Howard's and about 180 pills in the appellant's hand, and then the appellant's pills. And when he was told to, when Mr. Pierre was told to tear off these labels, maybe he didn't have a chance to get a hold of Mr. Howard's stuff, Mr. Howard's pills. So it can be inferred that we need all these pills together to prove the conspiracy of 28 grams or more. If this court doesn't have any further questions, I would go sit down.
Thank you, counsel. Mr. Vergosa?
Well, I mean, I see an amount I have to climb here, but, and I understand what the court's saying, that there are a lot of implications and there's a lot of indications that, something probably happened here. Why was really Howard in the car? Where was he going? Well, we don't know because he didn't testify and they didn't put any evidence on. But the issue still comes down to, there's a difference between being guilty and proving guilt. And I'm not saying that he's guilty. I'm just saying there's a difference between that. And when we're dealing with the state's case, let's say on Mitchie, what exactly is it he proved? Now, the state attorney's office is arguing, well, he took the labels off the bottles, but he was ordered to do that. It would be a big difference if Mitchie says, let me help you with this. There's still a conspiracy requirement to show there's an agreement and there's an intent. And I agree that you could always imply anything in there, but the implication is not the burden of proof the state has. The state has to prove it beyond a reasonable doubt. So and I also keep reinforcing the idea that even though Mitchie took the phone call from the from the CI, that's not a conspiracy. And even though he might have relayed the information, okay, maybe that does indicate, okay, I'm going to help you out with this. But that doesn't show conspiracy because you can't conspire with an informant. And relaying information to somebody is not a conspiracy because it doesn't show an intent or an agreement to do anything. And I agree with the court that maybe that does show he's interested in helping out get this. But helping out get this just shows you have a periphery area of this. Okay, so what do we have next with Mitchie? Mitchie's in the car. All right, well, and maybe he knows this is going to happen. I gave the case law where there was people who went to drug deals, knew there was a conspiracy, knew what's going to go on, and they were still in the periphery. Okay, so Mitchie's in the car. He's told take the labels off. He starts scratching the labels off. That's it. That means he conspired to traffic in these pills based on a phone call where he's not conspiring, because you can't conspire with an informant, relays information, and he's in the car. So basically, a relaying of information is the periphery. He's in the car, and he scratches the labels off because he's told to do this. And I suggest when you look at the opposite way, if he's really cooperating, why is it then, if Mitchie was really cooperating, they drove 3 hours from Miami to Fort Myers. If Mitchie was really doing this, why in those 3 hours of driving over with the pills, weren't they already scratching the labels off them? That doesn't make sense. And all of a sudden they're at the gas station and the appellant tells Mitchie to do that. I suggest that shows there's no conspiracy with it, or they haven't been able to prove intent or an agreement to do anything. Where's the agreement Mitchie had? He may have been willing to help, willing to assist, but that's not an agreement to be involved in it. And what exactly did he do? So he scratched the labels off because he was told to do it? I suggest that doesn't do it. And when you have Howard, okay, maybe Howard was willing to cooperate also, but also that's the periphery of it all. Where's his intent? Where's his agreement? And those are the two requirements the state has to prove. And I suggest when you look at the big picture, and I suggest it's easily clouded with these implications and how it looks. But when you look at really what the state proved and what the evidence is and what the state was saying, for example, the judgment of acquittal, why would the state be saying, well, we need Howard only to show he had a certain amount of pills to get to the trafficking amount. That's what they needed him. Where is any of that? So I suggest to the court, consider what the state actually proved here and not the cloud of the implications, because I think when the court considers what the state actually proved, it'll show that there really was no proof of an agreement and an intent on any of these alleged co-conspirators to deal with the trafficking. Okay. Thank you very much.
Thank you very much, counsel. The next case is Buziak versus Diaz.